on land expropriation without compensation are now done and dusted, and South Africans have their turn now to speak. The Constitutional Review Committee's first of 36 public hearings commenced today in Springbok in the Northern Cape, and in the next few weeks members of the committee will crisscross the country to have several hearings in every province. And to help us understand a bit more what's become quite a contentious issue, I'm joined in studio by Professor Nomboniso Gasa. Professor, welcome. Thank you for your time.
Thank you for having me. Good evening.
So I just want to start by just reiterating and putting this into a bit of context that, you know, it's the task of the Constitutional Review Committee to determine whether or not there needs to be a constitutional reform, and should this happen, essentially the willing buyer, willing seller sort of philosophy will kind of end and land expropriation without compensation will begin. But there needs to be a distinction, and I think that's what some people are wanting to find out, is that distinction between constitutional review and the land policy, because essentially you can't have one without the other, could you?
Well, I think firstly it's very important to be clear on what Parliament is doing, what the committee in Parliament is doing. They are looking specifically at Section 25 in relation to expropriation without compensation. It's also important to be clear on the fact that nowhere in the Constitution is there a provision that says willing buyer, willing seller. That was a particular interpretation, a policy interpretation. What the process is trying to determine is whether South Africans believe that changing the Constitution, that particular section of the Constitution, will make expropriation without compensation possible. Is there a need to change the Constitution? That's what the question is. A very specific, very limited question. The second issue is that Section 25 also looks at other aspects of land redistribution, restitution, and secure tenure system. So alongside, as this process that is looking specifically on whether we need to change the Constitution in order to have expropriation without compensation is unfolding as it is now, as you have introduced. There are other processes that are taking place. So those processes have not stopped. So one of those is the restitution, land restitution. That is, people who were removed, forcibly removed, people who have claims, and that process is unfolding. The Land Claims Commission is taking care of that process as we speak. Then there are other processes that already the department has been involved in terms of assisting particularly black farmers to have access to farming, to have means to purchase. Those policies, those programs are unfolding. Then there's the issue of the policy itself. One of the critical problems that are facing us in South Africa is that we do not have an overall land policy. And this was recommended by the high-level panel, which was chaired by former President Kgalema Motlanthe. And also in the early 90s, there was an attempt to have an overall land policy.
So you're essentially saying that the Constitution doesn't need to be changed, it's the land policy that needs to be looked into.
We don't have a land policy at the moment. That's the first thing. We have pockets of land policy that speak to different sections of the Constitution, of Section 25. We have, for example, Section 25(6) deals with communal land, that is people in rural areas, people who live in areas that are defined as communal land, as falling under traditional leadership, as falling under the former homelands and Bantustans. We have a bill that is in front of Parliament on communal land, or that ought to go in front of Parliament soon, on communal land. That bill will then, if it passes, it will then be legislation, and then policy will be made, and we'll see how the issue of people's ownership, customary rights, and land and property in rural South Africa is going to be addressed. But what I am saying is that I haven't made my argument yet. I've not said what you need to do. I'm just trying to differentiate that. It's important that we differentiate this, that so the key issue around policy is that we do not have an overall land policy in South Africa. A whole range of countries, for example, will have a policy, let's say, that says that land is private property. It must be vested in the hands of the private individuals. In other countries, you'd have policies that would say that the land is owned by the state and everybody gets into a lease agreement. In others, you'd have sort of like mixed kind of systems. Now, on Section 25 and expropriation without compensation, it is my argument, and that of many others, and it has been for a long time, that Section 25 makes provision for expropriation without compensation under certain conditions. And those conditions are, for example, for people whose tenure is not secure, for public interest.
Prof, can I just jump in here quickly? You're saying that there's nothing wrong with the Constitution, and many people would agree and say yes, there's nothing wrong with the Constitution, but it's just that it needs to be implemented. And if we need to implement all of these issues where policy implementation has failed time and time again, this implementing a new process, is it going to work?
Well, I mean, this is the key issue, because you see, if the problem was with the Constitution, government would have approached the Constitutional Court a long time ago, and this is an argument that we've been making for decades, and said, please give us a declaration. And once you have that determination by the Constitutional Court, then it doesn't mean you just go and identify land. You then go and have a piece of legislation that would cater for that. Government has never approached the Constitutional Court to say we are not able to expropriate because the Constitution limits us. And in fact, it's important to make this point, that there has been expropriation in South Africa where it has been necessary, where it has been in public interest, including expropriation without compensation. Where that has happened is where, for example, right now as we are talking, there's a big issue in Bondoland where they are trying to extend the N2, and people are being consulted, but it is clear that Sanral, which wants to build that road, that it sees that project as in the interest, as in public interest, that perhaps they might move those people and take that. So it's not as if it is there's no room in the Constitution to make expropriation without compensation. But also I want to make it clear that in order, if you are going to do that, you need to ensure that people who are affected, for example, this community in Bondoland, that actually they are consulted properly, that there has been prior and informed consent, that their rights, customary rights, and all rights that are enshrined in the Constitution are not discriminated against. Here, when we talk about expropriation without compensation, we tend to think that it only affects the agricultural sector, that it only applies to farmers. Actually, it doesn't. It applies to a whole range of other people.
But having said that, I mean, there's already been up to, or nearly 1 million submissions already before these hearings even started. So why not just hold a referendum? And will every voice be heard at these hearings, or are they just for show? Do you actually see what you've just said, where there's accountability in this process? Do you actually see that happening?
Personally, I think a a wrong. I think the problem was misdiagnosed to begin with. And I can say that because I'm an independent person. I think that politicians looked at a limited thing around expropriation without compensation. I don't think that is the problem. I think the problem is that firstly, we do not have an overarching legislation where all of us can understand what South Africa's vision is in terms of land. Secondly, it's important for all of us to know that the Constitution doesn't guarantee any of us rights to private property. What it says is that we cannot be arbitrarily denied property. So your property can't just be taken. But it's important to say that you don't have a right to actually say this land is my private property. Now, if we were going to have a conversation, a different conversation that I think would take us a little bit further, that conversation would be, what is your vision as South Africa about how land should be understood? Should we continue in this path? Should we improve on how we're implementing the kind of policies and law that we have? Or should we have a different vision for land?
Absolutely. Well, I think that's what a lot of people have been talking about, not necessarily in that specific frame, but at these hearings today. You know, we've had people saying the implementation is the gist of this issue, and when you get close to 1 million submissions coming in from people, it really makes you think that this is extremely important. It has become a contentious issue. It is extremely close to the hearts of millions of South Africans.
Yes, but you see the problem, you asked, shouldn't we have a referendum?
Yeah.
And I actually don't think you need a referendum, because if you have a referendum and you have not even defined the problem properly, we are going to answer a question that we should not be answering. The question that we should be asking is, how have we done in all the different sectors and categories of land reform, restitution, secure tenure, redistribution, development of communities, and so on, and redressing and redefining the kind of geography that we want away from apartheid special planning.
And if you look at those, breaking those down, if you look at those over the past 20 years, isn't that where we have failed?
But that's the issue. The issue is that the issue is around implementation. So you can have a perfect law.
Yeah.
But if you don't have the key institutions that are ready to implement that, then you're going to have a problem. And so that is where the problem is. So the problem is, where is it stuck? It's stuck at the level of implementation, and indeed in all those categories that I have listed.
The other issue is that the Constitution states, and you did mention this briefly, is that this should be done in the public interest, which is why, again, to mention these hearings, which is why, you know, the public's being engaged on this level. But how do you define the public interest if the Constitution already makes allowance for this?
Well, this is important. What we are seeing at the moment is a manifestation of what parliamentary rules require. And there have been lots of judgments in court, in constitutional court on this. We have a constitutional democracy. And what that means is that when law is made, there has to be space for public contribution and meaningful participation. So this is what Parliament is trying to do through its two houses, the National Council of Provinces and the National Assembly. So it's important that we understand that public participation is absolutely necessary in terms of the kind of democracy that we have. Now, what does the Constitution say in relation to all these laws that we have? The Constitution says that when you make laws, that people must be consulted, people must participate, but also that laws, each and every piece of legislation that we make, that is passed by South African Parliament, must meet what is called constitutional muster. That is, it must be tested against the Bill of Rights. So if, for example, we come out with an outcome that says there must be expropriation without compensation, then there's going to be a different process. That process is going to be looking at it in terms of the Constitution and saying, is it possible to certify this kind of law? Does the Constitutional Court agree? And we might just find that, in fact, the Constitutional Court might say you could have done it differently.
Who, in your mind, will benefit and who will not benefit? Because I think that's something that a lot of people are fearful of, is sweeping land grabs, which we know is not supposed to happen, and the way things are going, it is not going to happen. But there are people that have the fear, and there are people that probably will gain to benefit or seek to benefit from this.
Well, the Constitution actually defines that for us. Section 25(6) says, is very clear. It says people who have been adversely affected, whose land has been taken, who have been dislocated. It talks about trying to redress land in just and equitable manner. So people who were affected and who were made landless because of apartheid policies and discrimination, and the Constitution puts it in those words, are people who are supposed to benefit from land reform. But what is important is that we need to move away from this notion that this is a policy that is going to benefit you, and that is not going to benefit me, and it's going to take this from me and remove security from you, because we live in a society that is one of the most, in fact, I think it's amongst the top unequal societies in the world. So your mansions, your business, and all these things can never be secure. So if politicians were to approach this in the spirit of nation building and in the spirit of actually building a land program that is able to envision South Africa not just in the next 20 years, but actually able to say, in 200 years, this is where we're going to be. So we would have a completely different conversation. We would, for example, think about, and so when I talk about an overall policy, I'm talking about how you revisit the very nature of statecraft itself. It's impossible. It's improbable for me to imagine how you can really have a serious land reform and redistribution and serious land policy where land is separate from agriculture, where you make decisions about where people are going to stay, but you don't look at how that affects forestry. You don't look at other primary resources and natural resources like water, like sea, and it's going to be increasingly important for us to think about these things in such an intertwined way. And other countries are moving towards that, especially also in the context of climate change. So we have to be able to say, when we build a community here, this is going to be its impact on the environment, this is going to be its impact on the aquifers, this is going to be its impact on forestry, this is going to be its impact on spatial design and how people live and exist. And hopefully, with time we'll have secure rights, and hopefully with time we'll get rid of these ridiculous properties that we're building for poor people, the RDPs, that will be able to think of mixed ways in which communities are built, that there are certain amenities that have to go with where people live, and that people need to be able to have some land, they need to be able to have recreational facilities and all these things. These things are interlinked, and I think that after this, certainly, there is going to be a much more serious conversation that South Africans are going to have, and that is going to be on the policy and vision, and therefore resources that you put into that.
Prof, thank you very much. A very wise insight from a constitutional expert, Professor Nomboniso Gasa. Thanks very much for coming in. You're with Full View. Stay with us. We'll take a short break.